All right, ladies and gentlemen, 2 o'clock. Welcome back to your senior design seminar. Today, very special guest. Today's seminar will be on intellectual property and patents. And we have a very special guest today. His name is Caleb Nitz. He is a former MSOE grad. So he graduated in 2014 and is now working at a local law firm, I think in Waukesha. Is that right, Caleb?
Yep.
Yeah, in Waukesha. And he's been working as a patent agent for the last 6 or so years. So he's been through the ME program. He understands your pain. He knows what's going on. Since then, he's been working as a patent agent. And I think hearing his expertise in his talk today will be pretty exciting. So if you have questions for Caleb during the talk, I'd encourage you to kind of use the chat feature in the side there, sort of type your questions. And as we get to the end of the presentation, maybe we can have some student questions. Would be nice for him. So without any further ado, I'll let Caleb take over and get to his talk, and look forward to it. Thanks, Caleb.
Great, thank you. Let me just make sure I'm pulling up the right PowerPoint here.
One last thing I'll add is that I did upload Caleb's slides for his talk into the general folder for the senior design team. So if you'd like to follow along on your own machine with his slides, you can feel free to do that or revisit them later. Okay, go ahead, Caleb.
Okay, great. And just kind of a heads up, it looks like I'm not able to feature. It looks like it's for team members only, and I don't think I'm one of those. So at the end of the call, I might just have you read off the questions if there's time.
Sure, yeah, no problem. I'll kind of track it, and
okay.
At the end, just let me know, and I'll read them off. Okay, go ahead.
And if there's anything that seems pertinent that you want to pipe in and bring the question up, that's fine in the middle of the presentation as well. Okay. So like you said, my name is Caleb Nitz. I graduated from MSOE in 2014. So I've been doing this for about 6 years now, working with patents. And the basic gist of my job is companies come up with inventions. They send it to us. We write the patent, and then we prosecute the patent application for them until they get their patent. If this is a job that sounds like it would interest you, there are a couple local law firms, Michael Best being one of them, for which you can apply to become a patent engineer, patent agent. If you have any questions, I do have my email address on this first slide. You can feel free to send me any questions. Without further ado, I will get into the actual presentation and talk about patents. So in this presentation, I have a number of topics here. I'm going to try and cover them fairly quickly because there are a lot of slides. And last year when I did this presentation, I did not get through all of them. So I'm going to try and go a bit faster this time. So just kind of a basic overview of patents. It's not some new concept that's, that people are taking advantage of nowadays. It's been around since the writing of the Constitution. It's in the Constitution. Authors and inventors are given the exclusive right to their respective writings and discoveries. So what is a patent? A patent itself is a legal document, and it defines an invention. It is very similar to a property deed. Obviously you're not protecting tangible property, but it can be bought, it can be sold, it can be licensed, just like any other piece of personal property. The purpose of a patent is to exclude others from making, using, selling, offering to sell, or importing what you have claimed as your invention. It does not give you the right to actually sell your invention. The easiest way to think of this is if someone has a patent on the basic concept of a car, and you come up with the patentable idea of changing the shape of the car or adding some airflow feature to it. You can't sell your feature because you would be infringing on someone else's broader patent of a car. That's kind of a terrible example because no one has the broad patent of a car. And even if they did, it would be long expired. But that kind of gives you the idea of how patents can overlap one another. So when you get a patent, you do not have the explicit right to make, use, or sell what you have patented. It just prevents others from making, using, or selling what you have patented. And so the basic goal of a patent is to encourage creation. It gives you an exclusive right to make, use, and sell what you have invented. And if you didn't have that ability, would you really invest the time and the money to create it? This is especially important for pharmaceutical companies who can spend billions of dollars creating a drug and going through the rigorous testing. And at the end of it, if anyone was able to just copy what they have done, which is usually fairly straightforward with some pharmaceutical like medicines, because you have basically the list of ingredients there. And so the patent protects them and gives them a certain amount of time to make back their investment. It also just allows you to disseminate knowledge. You're basically putting out into the public exactly what you're working on. And it's a quid pro quo. You give some and you get some. When you give the public this knowledge base from that you have built, you're given that exclusive right for 20 years of your patent. Once that 20 years is up, it's donated to the public and anyone can practice it. So if you don't have a patent, that's not the end of the world. There's no requirement that you have to have a patent on anything. But if you don't have a patent, the free market takes over and anyone can legally copy or reverse engineer what it is that you have made, unless there is some other special protection by law. So reasons why you'd want a patent: it protects your R&D. It can provide some defensive measures if you have a competitor that you are trying to prevent from copying what you're doing. Sometimes just the threat of being sued is enough to deter competition. You can also license your patent, which can be an additional source of revenue. And obviously, if you have a bunch of patents, you can market that you have the patent on this particular feature, which is a selling point for some consumers. So under the broad umbrella of intellectual property, there's really three main categories: patents, copyrights, and trademarks. And these three get confused very, very often, especially in the media. If you read an article about a copyright or a trademark or a patent, it is 50-50 chance that they are going to get the wrong one. So it's good to kind of know the basics of what these are. As I've said, a patent gives you the right to exclude others from practicing your claimed invention. You don't actually have to use your invention commercially. A lot of patents have some crazy ideas in them, but they're never practical enough that they actually get used, and that's fine. It's not the best use of money, perhaps, but it's okay. And your rights with a patent only last 20 years from the filing date. With a trademark, this is like a slogan or a company name can be trademarked, and you have to use your trademarks, otherwise you can lose them. An example is Just Do It is trademarked by Nike. Greek Freak is trademarked by Giannis. And they do last an unlimited amount of time, but you do have to use your trademark and defend your trademark, otherwise you do risk losing it. So sometimes you'll see a news article. I think there was one recently that Giannis Antetokounmpo's lawyers had sent a cease and desist to a local artist who was using the term Greek Freak. And you think, well, that's kind of scummy. This person is making $20 on their art, and they don't really deserve to have big nasty lawyers coming after them. But it is an actual requirement in having a trademark, is that you have to enforce it. And then the third one is copyright, and copyright is more for like a book. A book can be copyrighted, a character can be copyrighted, so Mickey Mouse. And so that does last a limited amount of time, which is the life of the author plus 70 years or 120 years from its creation. There is one fourth one that is technically intellectual property, but isn't as well known. It's kind of a trade secret, and that is a trade secret. I'm sorry for that joke. So the difference between a patent and a trade secret is that the trade secret does not ever become public knowledge. And a good example of this is the formula for Coca-Cola. Nobody except the certain few people who work at Coca-Cola know the exact recipe, and that's for the best. If Coca-Cola tried to get a patent on their recipe, they would have to tell everyone, this is how you make Coca-Cola, and they would be protected and no one could do it for 20 years. But once that 20 years is up, anyone could make it then, and they would, be out. So for something like that can't easily be reverse engineered, sometimes it's a better route to go with the trade secret and just kind of keep it internal and not tell anyone how you do something. So there are a couple different types of US patents. And this is something that, again, similar to the patent, trademark, copyright, it kind of gets used incorrectly a lot. You don't file a patent, you file a patent application. A patent is the final thing that you get that actually gives you legal rights. A patent application is a piece of paper that needs to be reviewed by the US Patent Office, and it might be garbage. There might be nothing useful in there, but that's still yet to be seen. So a patent application is something that you file with the US Patent Office, and it publishes 18 months from filing. This is just the point where it becomes public and everyone can review it. This is, again, not a patent. A patent issues or is granted from the patent application, and that's after it's been reviewed by the Patent Office, and the Patent Office makes the determination that the concept that you want patented is new and it's not obvious in view of what's already out there. If they've made that determination, you can have a patent, and that's when it's granted. Once you file a patent application, though, you can mark your products as patent pending. So the most common type of patent, and the one that you'll see most often, is a utility patent application. You're defining an invention in terms of its structure and its function. It's exactly what it sounds like, and that's almost everything that you do is going to fall under this category outside of a design. If you want to protect the artistic design, the ornamental design of your product, you can do that. And that's with a design patent. And the most popular example here is the one that's shown. This is Apple's patent to a rounded edge on a cell phone. I'm not sure if you can see that all that well, but there are some dashed lines. Those are not part of what's being claimed. What they're claiming is literally just this surrounding bevel, and then I believe the circular button as well. And they have sued a lot of other cell phone manufacturers based on this design patent. And design patents are relatively cheap, and I think they made millions of dollars on this. So sometimes design patents are filed merely to protect you from people making knockoffs of your product. Other times it can be used very strategically, like this one, to prevent competitors from making good-looking products. So in a utility patent, things that you can patent include a process, which can be like the manufacturing process, or the way that you would use something. And you can also patent a machine or an article of manufacture, composition of matter, or any new and useful improvement thereof. And that's what most patents are. You're very rarely going to go out and try and get a patent on a new thing, because new things don't really come about that often. Usually what you have is you have something that already exists and you want to improve upon it. And so that improvement is what you're trying to patent. Parts of a patent application, I'll kind of go over these a little bit quicker. So in a patent application, you're going to have a description, which is written details describing your invention in as much detail as you can. They have to be enough detail to enable someone skilled in the art, which is a kind of a legal term, just someone who knows what they're talking about with this technology. Your drawings and your description have to enable someone to be able to make and use your invention. That's the trade-off. When you file your patent application, you have to do a good enough job of describing it so that someone can actually use that information to make it themselves once your term is up, once your 20 years is up. And then the claims. The claims are far and away the most important part of the application. They define with very, very specific terminology exactly what you are protecting and what you can sue someone over if they infringe your patent. Every word is important, and every word has to have a very specific meaning, often described in your application, in order to provide the clearest patent coverage that you can. An example here would be, I claim a pencil including a piece of lead and a red eraser connected to the piece of lead. In that example, if that's my claim and I get that through the patent office, again, a ridiculous example, I can stop others from making, using, selling, offering for sale, or importing pencils that have a piece of lead and a connected red eraser. If they have a blue eraser, I can't stop them from selling that. Again, a ridiculous example. Here's some examples. It's not really all that useful to look at on a small screen. But here's a good example of a claim. What is claimed is a seat comprising 3 legs, a seating surface mounted to the 3 legs, and a backrest coupled to the seating surface for supporting the back of a user. Obviously, that is not the easiest thing in the world to read, and it gets way more complicated than that. But if you read this, you kind of think, okay, yeah, that basically describes a chair. Now, if I show you this picture and you look at it and you say, okay, that has 3 legs, it has a seating surface mounted to 3 legs, and it has a backrest coupled to the seating surface for supporting the back of a user. If someone tries to sell this chair and I have this claim, I can stop them. And you might look at the claim, you might think, well, maybe the backrest isn't coupled to the seating surface. I mean, there's that black L-shaped bar in between. But here, that's one of the instances where, you know, the term coupled broadly covers anything directly coupled or indirectly coupled. So this would actually, this claim would prevent someone from selling this chair. I'm going to go through a couple other examples of chairs, and this is the point where I'd usually ask people to raise their hands and tell me whether they think it's would be covered by the claim or not. I can't really do that, so I'm just going to kind of cheat. All right, you look at this one. This is a stool, I would call this, but it is still a seat. It has 3 legs. It has a seating surface. It doesn't really have a backrest. And because it doesn't have every feature of the claim, you could sell this chair and I could not stop you with my claim. Now, what about this chair? We've got a seat. We don't have 3 legs, we have 4 legs. We do have a seating surface and we've got a backrest. Could I stop you from selling this chair? And the answer, and this is the one that catches people, is yes, I could. Because this does have 3 legs. It just also happens to have a 4th leg. And that's one of the nuances that you have to be careful for when you're reading patents, is what the claim is claiming is literally only what's written there. You're not excluding anything else. So this claim could otherwise read a seat comprising 3 legs, semicolon, a 4th leg, semicolon, and that would be narrower, but it would still be, it still just kind of shows that this does cover something that has more than 3 legs as well. And then this is getting a little bit deeper into claim writing, but you'll see when you look at claims, there's not just independent claims, which is what claim 1 is. There's also dependent claims, and these claims depend from claim 1. And so you look at claim 2, and it says the seat of claim 1 wherein the seating surface is made of leather. Now, we've already said that this type of stool is not going to be covered by claim 1 because it doesn't have a backrest. But what about claim 2? Because the claim 2 says the seating surface is made of leather, and that seating surface, you can trust me, it's made of leather. And the answer here is that neither of these claims are going to cover this stool. And that's because claim 2 is dependent from claim 1, which means it includes every feature of claim 1, and in addition includes this additional feature that the seating surface is made of leather. So if you don't infringe an independent claim, you're not going to infringe any of the dependent claims either. So the typical process for filing a patent application, you have 1 year of a grace period in the US for making this determination. And this grace period starts when there is a sale or offer for sale, a public use, such as a trade show or a senior design presentation that you would give, or any publication, like in a journal, a newspaper, anything like that. Once you have a public disclosure like that, in the United States, you have 1 year to file your patent application. If you don't file it by that point, you cannot obtain a patent. So it's very important to kind of watch for those deadlines and watch for any point where your invention is used or displayed in public. And so the overall process kind of goes where you come up with the invention that's conceiving it, you document the invention, you send the documents to a patent attorney or patent agent. They will prepare and file the patent application. They will prosecute the patent application, which is where they kind of have discussion is a kind word, is more arguments with the US Patent Office to say why your invention should be allowed as a patent. And then the patent either issues or is abandoned. I'm actually going to take one step back here. When should I file for a patent? I think I'm going to get to this in a later slide, but patent applications are expensive. And especially if you have a patent agent or a patent attorney help you with it, there is a lower cost option that lets you delay filing your patent application by a year, and that's called a provisional application. And a provisional application, you can basically take all of your information that you have, you can dump it into a document, you include images, you include description, and you can file that with the US Patent Office, and it's fairly affordable, especially for a lone inventor. And then you have an additional year that you can postpone with filing a non-provisional application. The provisional application that you file, the cheap one, it's not ever examined by an examiner, but basically what it does is it helps you avoid any headaches that may arise from, okay, well, I'm going to be presenting this to the client or the public, next week, but I don't have any protection. What do I do? Should I do something? You can file that provisional patent application, which is basically just a data dump to the patent office that says, I invented this and I invented it before this date. So as part of the patent application process, you don't actually have to have a prototype or a commercial product in place. As long as you have an idea and the idea isn't gibberish, I would say, you can still file a patent application. It is a multi-year process. From the time you file it to the time the US Patent Office even picks it up to look at it for the first time is usually at least 18 months and often over 2 years. And the overall process, because there's prosecution that happens after that, can take an additional 3 to 5 years as well. And it's also expensive. The fees can pass $20,000 over the life of the patent. There's fees that have to be paid when you file the application, all throughout prosecution of the application. And then even when you get your patent, there's renewal fees at the 4, 8, and 12-year marks that basically say, I still think this is of value to me. You have to pay the patent office some more money there to even keep it alive. So it is an expensive thing, which is why usually sole inventors don't typically file for patents. It's usually when you're part of a company that you do, but it's not impossible. And that $20,000 mark, you don't have to be anywhere near that if you are able to do some things by yourself.
Are you going to talk about sort of how patents work if you're working for a company or a university in the talk at all?
Yeah, I can. Let me.
I mean, maybe we can get it to the end. I just didn't want to like jump the gun on a question if you're already going to talk about it. So just keep going with what you got, and we'll address it at the end.
Is there a specific question?
No, there's not. It's just a personal curiosity, I guess. But okay. Go ahead. Sure. Keep going.
Okay. So let's see. I already did that slide. So what gets examined? So the patent examiner is going to look at your application. Again, if you file a provisional application, it's never going to be reviewed. It's just a placeholder. But if you file a non-provisional application, there's going to be a few things that they're looking for. They want to make sure that what you have claimed is novel. They need to make sure that what you are claiming does not exist already as you've claimed it. And they need to make sure it's non-obvious. And this is where there is a lot of room for arguments, because what is obvious is not all that well defined. So if you have a chair with, if chairs only exist with 3 legs, and you come out with a chair with 4 legs, and you say, hey, this is this great new thing, I have a chair and it has 4 legs, the patent office might say, hey, you know what, even though this doesn't exist yet, it's obvious. You're just adding an additional leg. It's not providing any non-obvious advantages. And that's where a patent attorney, patent agent is going to argue and say, well, you get some additional stability. You're able to rock it backwards and forwards, and it's not going to, be supported on only a single leg. There's different ways you can go about it, but it is kind of a tricky threshold to get past to actually get your patent. So this is kind of, if you were to file a patent application and it gets examined by the patent office, what they would send you is an office action. And that's basically setting forth any of their rejections based on prior art, which is typically other patents that have already been filed, patent applications that have already been filed. Or it can be literally anything else that exists. It can be a web page, it can be something from a textbook. It can be literally anything that existed prior to your filing date for your application. And they can use anything, again, from before that filing date against you to prevent you from getting a patent, from getting a patent. And then the applicant or the patent attorney files a response to the office action, which is basically either arguments or amendments to the claims to try and get pushed towards allowance. And you keep doing that until you get a patent or you abandon your application. So how do you know if you'll get a patent? There are absolutely no guarantees. The interpretation of the claims and prior art can vary, and what is obvious is very subjective. There are also a number of patent examiners at the patent office who are not the brightest bulbs in the bunch, and maybe they just don't understand at all what it is you have filed, which is why the patent attorney needs to very kindly and gently explain to them what it is that you are trying to claim and why it is different from what they are trying to say is already out there. So I have a patent. Now what do I do with it? So it is self-policing. No one from the patent office is going to say, hey, look at this, someone is infringing your patent. You have to kind of keep an eye on your competition. And you can send a cease and desist letter that says, hey, I've got this patent, it protects this, and kind of look at what you're doing with this product here. So you can either stop or you can pay me some money, or you can file a lawsuit, although that can be expensive. And if you are a sole inventor, I don't think you're going to be doing that, which is something you want to take into account if you do try and get a patent. Are you actually going to be able to enforce it yourself? Will you have the money to do it? So the patent terms, once you get your patent, you have 20 years from your filing date until it is part of the public domain. And you do have to pay fees at that 4, 8, and 12-year mark in order to keep it alive. So can someone stop me from using my invention? So again, a patent only grants the right to exclude others from practicing the claimed invention. So it doesn't actually allow you to practice what you have invented if you are also infringing someone else's broader patent. So my company makes a product. How do we know if it infringes a patent? So you can conduct a clearance or a freedom to operate search. And this is, there are some pay programs you can use to do this, but Google Patents works very well. All patents are categorized. There's a system in place where you can search for, you can narrow down your search results to only ones that fall within a certain category. And so Google Patents is a really easy way to actually do a quick search. These searches are never truly exhaustive because there are millions of patents out there and you're not going to spend the time to look at every single one of them. But what you do is you can look at other patents that are out there and you can try and assess the risk, the infringement risk, by looking at those claims.
Yeah, don't those patents have like keywords on them a lot of times, and that's how like they categorize them?
Yep, there's keywords. There's also the U.S. Patent Office and the PCT, or World Patent Office is kind of a misnomer, but there are different classification systems in place. So you can start off with a super broad search for agricultural, and then within there's going to be 20 different ways you can narrow it down further. And then you can keep narrowing it down until you get to what you really think is the crux of your invention. And then you've got a much smaller pool of applications to look at. But basically the way it works is, you have a design that you are interested in making, an invention you're interested in making, and you want to know if anyone else has done this. So what you do is you determine what features you're specifically interested in, what improvements you've made that you're interested if anyone else has a patent on. And then you kind of have some back and forth conversations if you do go through like a patent attorney to determine what features are actually relevant. Then what you're going to do is you would look at the independent claim specifically, because again, if you don't infringe an independent claim, you're not going to infringe a dependent claim. So here, claim 2 at the bottom, the stand of claim 1, that includes all of the features of independent claim 1. So if you are looking at this from a clearance perspective to try and determine whether this is something that you would infringe, you can just look at those independent claims. And you try and highlight different portions of the claim that you don't specifically do. And that can be used as a non-infringement position. Again, this is kind of more legal work, so not something that you would really be expected to do yourself, but it's good to have kind of an understanding of, if you're an engineer at a company and you get back these search results, at least how to read through them and understand what the patent attorney was trying to say in their report. Looking at it from the other side, if your product infringes a patent, what can you do? You can conduct a defensive study, which is, the patent office, like I said, they've got some real good people there. And sometimes they make mistakes and they let through a patent that shouldn't exist. And so what you can do is you can do your own search of the prior art, and you can say, well, it looks like what they've patented or what they've claimed already exists in this prior patent or prior publication. So they probably shouldn't have gotten. And that's something that's one route you can take. You can also design around it. And this is probably the biggest way that an engineer would handle this problem. So if I have a patent and my claim says a pencil including a piece of lead and a red eraser connected to the piece of lead, you can design around that so that you don't infringe the patent. You can either make the pencil using graphite instead of lead. You can make the eraser blue instead of red. Again, this is a simplistic example, and it would usually be a little bit more challenging than this, at least if the patent attorney who drafted the claims did a good job. They would never include a red eraser. That is far too easy to design around. But designing around is really going to be your best way to do that. It is additional work, obviously, and that work might be challenging, and it might make your product more expensive or more difficult to manufacture. But if you don't have to pay someone royalties, it can save the company, potentially millions of dollars on royalties or infringement costs. And that is your other alternative is you can pay a small royalty to the company with the patent and essentially license it from them. Wow, I made it to the end of the presentation. This took me 45 minutes last time. I am done in 30.
Yes. Well, we didn't keep interrupting you and asking questions, but we do have a lot of questions here, like in the chat. I think like people pretty interested in a lot of things here. So I'm just gonna kind of like run it down with some of the questions. I got some of my own questions too, so
Sure. Yeah, go for it.
maybe I'll just like pop in and ask. The first one comes from Xavier. This goes back to when you were talking about copyrights, and he says, doesn't copyright keep getting expanded by Disney so they never lose Mickey Mouse?
Yeah, it basically does. It's getting harder for them to do it, but there are some provisions in place, I believe, that'll and you know, this is not my area of expertise. I deal more with patents, so this is more just a curiosity for me as well. But my understanding of it is that they're not actually at risk of losing Mickey Mouse because they keep using him in new movies, books, whatever
Sure.
it is. What they're at risk of losing is the copyright of the specific work of, you know, Willie. They might not be able
Sure.
to stop people from selling that specific movie in the
Got
future.
it.
Yeah, Disney
The
does
like original movie. Yeah. All right. Jack Turasek asks, what defines new or obvious? I think you kind of covered that, but it seems like quite a bit of wiggle room in sort of defining that. And based on your very high opinion of the people in the trade office, which I, read between the lines there, maybe you agree or disagree with them at certain times. What do you say about that?
Yeah, I mean, honestly, that's the best value in having a patent attorney prosecuting your application for you, is that they're able to provide the high-level arguments that kind of fall within the legal restrictions of new and non-obvious. New itself is fairly straightforward. If what you have claimed does not exist yet in any way, it is new. So it's a fairly easy hurdle to pass. Although if you are trying to really broadly claim something to try and cover basically any alternative that a competitor would come up with,
like a car.
Right. Then you're going to have a harder time passing that new burden. Non-obvious is where it becomes so much more difficult. And
I imagine
like for a lot of arguments.
I think about like the curved edges of a cell phone. I'm like, well, that seems pretty obvious. I don't know how they patent like curvature on a cell phone. That seems ridiculous to me, but okay. Right. So let's keep going with the questions here. One question is, could you expand upon importing protections that a patent offers?
Right. So this is actually kind of one thing I didn't cover is that patents, if you get a patent in the United States, that prevents people from making, using, selling, or importing in the United States.
Yeah.
Someone in Europe or in China can still make or copy whatever it is you're doing. And if you do want to file in all of those countries, which you definitely can do, it gets much, much, much more expensive. Sure. I mean, you're talking on the order of hundreds of thousands of dollars for a single patent application if you want to file in a bunch of countries. In terms of importing, as far as I can tell, I've never dealt with the issue of someone importing without the intent to sell, which is really what you typically fall under is you can prevent someone from selling or intending to sell. Importing is more, I believe it's just more of a physical way to define that you are intending to sell. Obviously, if you're bringing something in from another country, there's likely a reason for it.
Yeah.
But it's something that I haven't had to deal with too much personally.
Yeah. So you've mentioned cost a couple of times, but didn't ever specifically say a number. Like, if I wanted to hire a patent attorney to write a patent for me on this new design patent that I have, what ballpark number might I consider if I was doing this out of my own pocket?
If you are a sole inventor, I honestly wish you the best of luck. Realistically, it can vary significantly. Where I work, we typically deal with companies more than sole inventors. Patent attorneys are lawyers, and they do sometimes have thresholds of pro bono work that they need to do. So that might be an option to consider if you are looking to file a patent application. A lot of colleges, I know UW-Madison has kind of a law clinic where you can go to them and they will help you prepare that patent application. I would highly recommend looking at some of those options if you are a sole inventor. I'm not saying you can't go to a patent attorney, but I would estimate a non-provisional patent application would cost between $5,000 to $8,000 to file. And then any correspondence with the patent office, I mean, you're looking at another $1,000 to $2,000 essentially per office action response.
Yeah.
And there's patent office fees on top of that as well. For a sole inventor, they're not too restrictive. They're in the low hundreds of dollars range. But if you do have that help of a patent attorney, it does get fairly expensive.
Right. I want to follow up on this question by saying, so what I understand about if you invent something at a university, like let's say MSOE or Wisconsin or wherever you are, and you think that that invention is worthy of patent and you're interested in getting the university to help you, can you explain some of the mechanisms and what you might give up by having the university sort of provide the fee for making the patent?
So here's actually something that's a great question, and is helpful for the students and the staff, I would say, and the professors. If you use university, or if you're at a job and you use your workplaces in any way to aid you in creating your invention, the university or your company is likely going to have legal rights to that invention, and it's usually part of paperwork that you would sign when you sign on with a company or a university. Is anything that's invented using the resources. So, like if you use SolidWorks, and that's something that MSOE is providing to you, or Creo or whatever it is they use now, that is something that is likely going to result in the university having rights to your invention. Which is why if you do intend to invent in anything as a student or a professor or anything, or even at your job, find free software that you can download or pay for software. Do not in any way use your company's software. Otherwise, they will go after it. It's a free invention that you're giving to them.
Yeah, I'm sure this has happened many times, and a lot of unhappy people have resulted.
Yep.
Yeah, so that's a word to the wise. And what sort of things might you be giving up if, for instance, it becomes intellectual property of the university instead of yourself as an individual? From what I understand, there's, like these patent offices at universities that will, write a patent for you and pay the fee. But then, if there's any royalties that come from it, maybe they get 95% and you get 5% or something like that.
Right. And that's likely part of, basis by basis paperwork. From a legal standpoint, you are likely assigning your rights to the patent application to the university. Almost any place of business has that as part of their employee contract.
Awesome. Yeah, so just watch out for that if you're working on a senior design project and it's something you actually are interested in pursuing on your own time and your own dime. So just be wary of that, students, I guess. Okay, maybe we get back to some of the questions here from the peanut gallery. If the application is obvious to another patent that is currently pending, can they be combined together?
No. So this is another area where it gets a little bit tricky. If you are the owner of two pending patent applications, and one is found obvious of the other, as long as they are co-owned and I believe filed within a year of each other, the one cannot be used as prior art of the other. So in that regards, you do have a little bit of wiggle room. If you have an improvement to something that you previously filed on, you do have a window of time in which you can file that improvement, and it won't be found obvious in view of your previously filed application.
Got it. Okay, another one coming in here from Eileen, and I like this question. She asks, is a law degree recommended if you are interested in intellectual property? And I want to dive in on this a little bit more and expand upon it myself. Is, you have a mechanical engineering degree from MSOE and no JD, from what I understand, correct? Right. Okay. So you don't have a law degree, but I mean, you're working as a mechanical engineer in this patent office. So can you just describe sort of like your job versus maybe a job of someone with an engineering bachelor's degree, and then they continue on to get a JD in patent law, right? Can you just maybe talk about that and the differences?
Right. Yeah. And I'll definitely say becoming a patent engineer or patent agent is not something that I even knew existed until senior year when I had a presentation like this in my senior design class. And so it is definitely a route you can take without having a law degree. Like you said, I do not have a law degree. I just have my undergrad from MSOE. It is something that you need to have a science degree in as your undergrad, and you can continue to become a patent attorney by getting your law degree. But in terms of what I do versus a patent attorney, there is a lot of overlap. I had to pass the patent bar, which is a 6-hour test, and it's terrible, but I didn't say that. And that allows me to practice in front of the patent office. I can give no legal opinions, and I can't do anything else in the law field. But in front of the U.S. Patent Office, I can do essentially anything that a patent attorney can do, at least when it comes to patent prosecution, from the steps of drafting a patent application to prosecuting the patent application, responding to office actions, all the way up to getting you your granted patent.
Got it. So, what would be different then between what you currently have and someone with a JD might have? You said for no intents and purposes, it's basically the same. Like, why would you ever go for a JD?
Well, I can't become partner at my law firm.
No, but pay difference, I guess. I don't know.
There are a number of things. Giving legal opinions is something that I can't do. So if someone says, "Hey, I just got a letter. I got a cease and desist from this other company. They say that I'm infringing their patent. What can I do?" I can't respond and tell them, "Hey, don't worry about it. You're not infringing their patent." That's a legal opinion, and it's something that I cannot legally give. And on the back end, if there's ever a lawsuit over a patent, it's something that I can't participate in.
Got it. So one other follow-up question, then we'll get to the next, is of the patent attorneys, people with JDs that you work with, how many of them have undergraduate engineering degrees?
Every single one of them.
There you go. So a technical background, almost 100% required to go into something patent related. And that's more or less, I think, comes down to what you were saying about being able to understand or being, scientifically literate and able to replicate some of the claims that are made, because you see a lot of these engineering drawings, they're not technically engineering drawings, but they're, figures and pictures that you have to be able to interpret and understand what's going on. So I think that technical science background is incredibly important. And this is just one more field where that's applicable. So cool. All right. Maybe time for one more question here before we hit our 2:50 deadline. That comes from Mo. He says, can you give a general sense of IP laws in space? Interesting. Things like International Space Treaty, and it sets some standard for IP laws in space, but as someone interested in aerospace, etc., what IP laws exist for making claims on things in space? Any ideas there?
That's a fantastic question, and honestly, I don't really know. The basics, though, is even if something is used in space, it's going to be likely manufactured on Earth.
Likely.
Here on Earth, it's manufactured, it's invented, or it's sold. That's going to really be the determining factor on whether you can legally make, use, or sell it. Is where on Earth that takes place. Yeah. But obviously, I think they have like 3D printers up on the space station now. If something is invented and made up there, I honestly have no idea what would govern that.
Yeah, exciting. Well, I think we'll wrap it up here and say, Caleb, that was an awesome talk. I appreciated the little chair examples because there's so much nuance there. I didn't even really know about all that. So really appreciated. Great job. So thanks again.
Thank you.
And students, thanks for coming. And we'll leave it here. Okay.
Right.
Bye, guys.
Thank you.